Hi, everybody, and welcome to Raw Law. I'm Arkady Frekhtman. I'm a New York City personal injury trial attorney, and this is the show where you get to ask us questions live. So we respond to your questions and comments live, and you get that advice from a personal injury lawyer in New York. And I'm also admitted in Texas, and I've done cases with other lawyers. I've partnered all across the country. And I've been a personal injury lawyer since 1999, so about like 25 years. And so you get that information, you get that that live feeling. So yeah, I'm here. I'm ready to go. Come along with Uncle Joe says hello. How are you? You know what I may do? I may just jump into the chat for the channel. Maybe I'll do one or two questions in the chat for the channel, and then we can go from there. And then if people have live questions, of course, I'll prioritize the live questions. We'll jump back in here. And Mills Sapp says hello. Hi, how are you? Thank you for being here. Welcome. Let me see here. Oh, Manuratu says, hello, thanks for the live. I have a question. What happens to a pretrial conference? And Darwin says, hello, hi, how are you? Great to see you. Yeah, so the pretrial conference, usually what happens there is, you have a trial date. So this is your pretrial. So it depends on the judge. Sometimes at the pretrial, you'll just try to settle the case, right? They treat it like a settlement conference, and they say, look, this is our final pretrial. If you could settle it, let's do it. If you can't settle it, then you're going to get a trial date in about, like, say, a few weeks or a few months. You're going to get that trial date, and that's going to be the final, So that's usually what I've seen in New York. Now, in federal court, it's a little different because at the pretrial, they'll want to know who are you going to call as witnesses. Could you do a joint pretrial statement with the defendant's counsel, together? They want all these specifics. So it's almost like, an actual roadmap, like a table of contents for the trial. And they'll say things like, well, did you discuss like any objections? Is there any evidence you're going to stipulate to? But that's a little bit more in depth. That's more like federal court. State courts, for the most part, I haven't seen that because the issue with that in New York, for example, the reason why it doesn't happen is because they don't even know who your judge is going to be, right? Because you get one judge, which is an IAS judge, and that judge is handling all your discovery and all your motions. Then now you're on the calendar, right? So the judge says, okay, go pick a jury. They just give you a slip of paper. You go to the jury room, you pick your jury, and then I think randomly they say, go to Judge Smith or go to Judge Baker or whoever you get assigned to. So then that's the judge, your trial judge, that's going to decide all your motions in limine, your evidence, what's coming in, what's not, whether or not they allow for like demonstrative evidence, like PowerPoints or photos. So that's why, I think that it's not really, that's the way they do it. Oh, and Paul says, what are your thoughts on the subway case in New York now on trial? Oh, yeah. I haven't really been following that, but I did hear about that. That was the guy who was like a former Marine, right? And then somebody else was being very rowdy, so he had him in a chokehold. And so yeah, it's a tragic situation. I'd have to like look into the specific facts a little bit more. I mean, on the one hand, if the guy was being a menace, but he had like mental health issues, then of course, if he's being like a good Samaritan, but then maybe if he held him too long, they're saying that, you could subdue him, but you can't hold him so long that obviously you kill him. But I don't know. I'd have to like look into the details about that. But that's interesting. And that's more of of course, that's a criminal case. But that's actually right here in 60 Center Street or 111 Center. And that's actually where I used to do a little criminal defense. I did a few trials there. So it's actually a funny story. Like when I first started, I was doing personal injury, but I also did some criminal defense. And we did a criminal defense trial in the Bronx. Me and one other lawyer, we partnered on it. The other lawyer was a little bit more, experienced than me at criminal. He was like, in his 60s, he had like 30 years of experience. So it was a funny story because it was actually the husband, I guess his ex-wife, like he went to pick up a kid or drop off a kid. So he saw her for like 10 minutes and, they had he says consensual sex, but she accused him of rape. And so, but it ended up being an interesting case because he was being accused of rape. And I still remember this. And we were in the Bronx, we were doing this trial, and the judge just seemed like completely disinterested. He was like doing something else on the side during the trial, like marriages. Like back then, this was like a while ago. This was maybe in the early 2000s. He was doing like marriages, marrying people like while they're on trial for a rape. And then the judge said, "Do you want me to just do this without a jury? I'll do this." And then the lawyer, who was more experienced, my partner, he said, "No, don't do that because you'll just send them away for like 40 years or whatever." So we ended up, I remember the district attorney got up and she had the indictment. And she said, "You know what you could do? This indictment means that he's being accused of rape. And what you could do is you could confirm this indictment and say that it's true and find him guilty." And then she sits down. And then my partner, he gets up and he's wearing like cowboy boots. He's like a cool guy. So he gets up there and he picks up the indictment. He goes, "Yeah, you could sustain this, or you know what else you could do with this?" And he like crumples it up and throws it in the garbage. And then the judge was like, "Oh my God, you're not getting another copy of that." But then it ended up being good. We won the case. We actually ended up getting a not guilty verdict. And it came back like in 15 minutes. They came back not guilty. So that was one of my first trials that I did. But anyway, let's go back to your questions. Saren says, "Good evening. Hi, how are you?" And Mills says, "I have a question. A traffic light fell on my car while driving. I'm having to get a spinal fusion in the next 2 weeks. My question is sovereign immunity waived and uncapped in an event?" Oh, what he's saying, in an event that I need more treatment for injuries. Right. So it depends on like where it happened. I guess every law will be very specific on sovereign immunity. And, you'd have to do like you want to definitely make sure you have a good trial lawyer for a case like that, because, with a traffic light, sure, it's owned by the city, but there could be like companies, like contracting companies that go in and do something to them, like maintenance or repairs that might have like loosened it, or, you don't know until you really find everything out, right? It could be that the way it's hung, the hanging mechanism is some ABC private company, right? And then so you have to sue them, and then you get out of sovereign immunity. But yeah, you have to review the law in each jurisdiction. Like in New York, it's very specific. In other places, it's very specific. But I don't think sovereign immunity would prevent you from getting more treatment, because treatment is more like either using your health insurance, or you could, you use your health insurance, or you could just use like no fault if it happened in New York, right? Like I guess, yeah. So I mean, I don't know. Like I'd have to like that's a kind of question where I need to do a little bit of research, but definitely I think that's a good case. I don't think sovereign immunity would apply to something like that, because that's not really, especially he says it fell 2 weeks before, so they're on notice of some kind of negligence and they're not taking care of it. So yeah, that's on them. Okay. And then Joe says, "If the other party wants to extend the discovery, on what basis would the judge extend it? And does my attorney have to accept this request for an extension?" No, you don't have to accept it. You could say no. I mean, it depends on the reason why they're trying to extend it. So for example, discovery just includes everything, right? Like finding out information. So it could be like them trying to get documents. It could be them trying to take your deposition or take the deposition of somebody else, like a witness, a non-party. It could be the defendants trying to get you to go to another doctor, like an IME, DME. That's all considered discovery, right? So then usually, if it's not done, it's not done. Like, for example, if I ask you for documents, you give me something, but I still have a few more. Or if I take like one of your defense depositions, but then I learn, hey, there's more witnesses, I want to take more. So both parties usually agree that either it's done or it's not done, right? Either everyone is satisfied, hey, I've discovered everything there is to discover. I've done, and and everything. It's like more of the way the lawyer, plans and strategizes the case too. Like some lawyers may say, hey, I want to take every deposition, and take like, I don't know, 50 depositions. Other lawyers will say, look, I'll take 1 or 2 depositions. I don't want this to go on too long. I don't want this to cost too much, right? Because every time you take a deposition, you're spending money. And then they don't really go crazy with discovery. They say, look, just go to trial. So there's different philosophies about that. So but usually the parties agree. Either you have something outstanding or you don't, But yeah, just because they ask for an extension, they have to have a good basis for the extension, like a good reason. And then the judge ultimately either grants or denies the extension. So it's not like your lawyer can put in opposition if he thinks that there's no good reason, and then the judge will make the decision. So that's usually how it works with discovery extensions. And then Leonardo is here. He says, hi, hello, how are you? Gatry says, hello, Mr. Arkady. I've messaged you and called you several times and no answer. I have a few questions. Oh yeah, I'm sorry, I've been busy, but yeah, just text me and I will get back to you. I don't think you called me anytime recently, maybe a few weeks ago, but I've been a little busy with paperwork and with, my cases and everything, trying to get everything done. But no, I'm happy to speak with you. But I believe Gatry, I think she has somebody that actually helped one of my partners down in Florida. So it's always best to speak to the lawyer handling the case, because when you're in a different state like Florida, it's better to speak to that lawyer because they're actually actively handling it. Of course, I'm happy to speak with you too, but like, remember, I'm not actively handling it day to day. I'm here in New York, so I'm just doing my cases. But yeah, but if I found somebody for you, they're very good. So just trust them, deal with them. I think the person I found for Gatry is really, really good. He's got like $15 million verdict or something. So I'm sure he'll answer any question. And then Makwa Velas says, I had an accident in Queens where I was a passenger. The at-fault party was a truck with a $5 million policy. I had more than 1 year of physical therapy, arthroscopic shoulder surgery, microdiscectomy on the neck, and lumbar. How much can my case be valued at? Yeah, I mean, that's a good case. So you had an accident in Queens. It wasn't your fault. You were a passenger. You have a $5 million policy, and you have arthroscopics. I'd say arthroscopic shoulder, that's already like could be 300-400 for that. Depending on if there's anchors, it could even be higher, like 500. Microdiscectomy, if it's a full-blown surgery, usually worth more. That could make the case, closer to $1 million. And I think he says, and a lumbar disc replacement. Now, disc replacement is really serious too. So if you had both a micro and a disc replacement, I think that could be over $1 million easily. I mean, I'd have to like talk to you. The best thing to do is to text me 347-566-9595. Then we can like jump on a call. We could talk about it. I can give you some advice. What I've been doing for people is I've been looking up the case in the court's computer, which you could do. It's a public filing. So you could look it up in e-law, NYSIF in New York State, civil electronic filing. They all have something called web civil. I believe, it's called web crims is the criminal and web civil. And you could look up I think it's called e-courts, and you could look. So there's like a bunch of places where you could look up these cases and read about them, and then the documents are there. So meaning the complaint is there. Sometimes the bill of particulars. Sometimes even like photos, like a police report or bill of particulars will have a lot of information in New York. It'll have like all your what your lawyer is alleging the other side did wrong in terms of being at fault, and also all your injuries are listed there. So it gives you like a good synopsis. So then after I read all that, I could speak to you and tell you. Sometimes I find like crazy stuff. People think they have a good case, and then I look and the case got dismissed. And the reason it got dismissed is because the lawyer forgot to do something. It was just some silly thing. So I let them know because they don't even know these things, So sometimes you find out a lot of interesting things by looking at that. And then the other thing I could do is if you tell me who the lawyer is, like their name, John Smith, I could tell you their past settlements and verdicts. I could do a search. And sometimes we find, good things about lawyers, that they have really amazing results. And sometimes, we find that people don't have any results. They're just not trial lawyers, or they have bad results, like zeros, goose eggs. That's not good either. If you're looking for $1 million, you don't want to have somebody who's every time they go in, they get zero. That's, that's not good. So yeah, things like that. But I'm happy to do a call with you. Let's see. And then Aqua Shock says, is the procedure of negotiating medical bills down at the very end of the settlement process a common practice for all personal injury? And hey, Mr. Arkady, great to see you. Oh, yeah, great to see you. Yeah, absolutely. So yeah, usually medical bills, if you're talking about liens, yes, like liens usually get negotiated at the end. So for example, you settle the case, and then you look at what liens there are. I think they're mostly called liens everywhere. Some places they may be called something else, like I forgot the other states call them something else. But anyway, it just means that, like, for example, the doctor treated you, but there's no way to pay the doctor, right? So the doctor's treating you for free, but then at the end of the case, when you say win $1 million, the doctor's going to say, well, I treated you, I didn't get paid. Here's my bill for like $1,000. Pay me, right? So then you call the doctor and you say, but sometimes it's not $1 million. Sometimes it's like 100,000. The doctor doesn't want 1,000. He wants like 10,000 or 20,000. So you try to negotiate them down. Yeah, absolutely. We do that all the time. And he also says sidewalk bicycle accident case, 3 herniated discs to the cervical spine with impingement, 50% torn rotator cuff and broken ribs, $100,000 State Farm. And there's a 2-level ACDF recommendation for surgery, reconfirmed to the level ACDF recommendation, ongoing long-term pain. Yeah, they should just give you the 100. I mean, if you have all those injuries, torn rotator cuff, and you need a ACDF, and that's worth like millions. So if they only have 100, they should just tender it. State Farm has been super cheap. I actually did a video. This happened to me. I was supposed to go on trial against them November 18th. And so they did the same thing to me. They were trying to get me to take $25,000. I just sent them a letter. I said, look at my damages. I put it right out there. I did a video about this. It should premiere maybe like next week. I think we just shot it on Friday. But anyway, I just said, look, here's a letter. Settle the case for 100. If you don't, that's fine. I'm going to trial, and I think it was scheduled for November 18th. But at trial, I'm going to ask for like 1.2 million, and I had it all like mapped out. Like I have 80,000 in wages. I had like 300,000 past, 500,000 future medicals. Everything was like, look, and here's my client's like his biography. I did a full biography on him. Like here's his human story. Like before he used to do a job that he loved, he was passionate about it. He would actually help people who needed wheelchairs, that he would like fix their wheelchairs, either come to their house and fix their wheelchairs, or if he couldn't, then he would take their wheelchair, put it up a ramp into like a truck, take it to the, I think it was like National Wheelchair or not National Mobility, take it there, and they had a shop, and he would repair it and then bring it back. So one time he even changed somebody's wheelchair battery in the rain with the person in it. He was like really passionate. He gets hurt. He also has like a discectomy, and he can't do what he loves to do. So he can't, like, for example, do things around the house. Like his wife has to do the dishes, take out the trash, go to the laundry. He can't do any of this, right? But then most importantly, at his job, he can't do that anymore, where he takes a wheelchair and he pushes it up a ramp. So he has to quit. And then his other jobs are more like working at Target as a supervisor. Then he can't do that because that's physical. Then he gets a job. So basically, it's like one job after another, much lower level. And he never really could find himself. So we both claimed, see, it's like two things. You can claim the actual wage loss, the paycheck losses financially, because he's making less and he had all these periods of time, like 6 months where he's not working at all. But more importantly, you could also claim the loss of enjoyment of life, because his job was his identity. It was like who he was, right? And he can't do that. So he lost that. So that's like, what's that worth, right? That's like priceless. It's who you are. And then, so we made it much bigger. So we said, look, here are all the damages. And I did a video about it. So watch that video. But I think it's pretty good. And then by the way, they just paid me. They're like, oh, here's the 100. Because before they were at 25. And I was like, come on. But, that's a crazy, they're just being cheap. And then Joe says, does the other party have the right to make an IME-DME request until the discovery is completed? Or how much time do they have after the deposition? Yeah, usually they do it after the deposition. I mean, how much time will depend on the court order. You have to just read the court order. Like in New York, I think it's like 60 or 90 days. There are deadlines for everything. So they'll say motions for summary judgment are usually 120 days after filing of a note of issue. IMEs might be like 90 days. It's all like pre-printed form. You just read the pre-printed form. I don't remember. In New York, I think it's like 90 days after the deposition. They have until to designate a doctor and then hold the exam. Yeah. But it depends where you are. If you're in a different state, it might be different. But yeah, something like that. Usually it's a few months they have. And he says, how long do they have, to legally request? Because it's been 4 months since the deposition and they still haven't asked for it. Yeah, I mean, like usually they just go by the court order, but definitely ask your lawyer. Your lawyer should know that, they should be communicating with you. And if they're violating the court order, meaning the defendants, then just make a motion, strike their answer, preclude them from using the DME at all, and just file a note of issue and go, or file, say I'm ready for trial. They don't get a doctor. They had their opportunity. They waived it. Hey, no one's going to force them to get a doctor, right? They have the power to hire a doctor to like examine me, but maybe they chose not to, right? It's a choice. You could choose to do whatever you want. And look, they chose not to follow the court orders. So if court orders have any value, you say, Your Honor, if your own orders have any meaning, any value, then we have to follow them, right? We can't just like ignore them with impunity, right? And then that's it, and just preclude them. Okay, and then Askia says, hi, sir, how are you? I had a rear end accident last year on Halloween Day. I did an MRI, chiropractor, pain management, but no injection in the whole year. Now I stopped treatment. What do you think about this case? Do I need to disposition and all other stuff? So you had a rear end last year, and you did like all your physical therapy treatment. But I think it says no injunction. I think you mean no injection, or no, I'm not sure what that is. But anyway, I mean, yeah, that's pretty much what you're describing is like pretty much like every case. Like if you get into a car accident, people get physical therapy. So yeah, of course, that's pretty much every case is like that. Now you have to get diagnosed, like, make sure you do all your MRIs, like you have a tear in the knee and the shoulder and the, if you need an injection, like an epidural or, whatever it is, you might have a bulge or herniation. And then, just, you could either settle it or you could put a lawsuit, start a lawsuit, and then maybe you'll get more, but it might take a little longer. I would speak to your lawyer, see what's going on with it. But yeah, it sounds like a good case. You get rear-ended. Find out how much insurance the car that hit you in the rear has. That's critical. So it's been about a year because Halloween was like a few weeks ago. This has been about a year already. I don't know what state you're in, but yeah, feel free to also text me. We could chat. If you text me, just include like brief facts, 1 or 2 sentences about what happened, just telling me a little bit about the case, your injuries, your city, your name. That's pretty much it. Really, what I need is just to be able to see like what happened. Like, how you watch a movie and you see what happens on the screen. I want to be able to see what happened, how you got hurt, like rear end car, slipped and fell on water, ceiling fell on me, whatever it is, I want to be able to see it. Sometimes people send me these long texts, like, it's like War and Peace. I have to read like a book. I don't have time to read a book. And some of it is like, there's nothing in there that really matters. Like, I don't know why people write these things. Just keep it short, just like a sentence, like for hitting the rear, car change lanes, I have a torn meniscus. Actually, the way people write it here in the comments is really good. You guys are good. Sometimes people write me these things. I don't even know what it is, but I try to respond to everyone, but sometimes it's hard because if it's in a certain format, it's just easier. I could be like, oh, boom, 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 and I could like know how to deal with it. I can call you. We could set a time, do a consultation. Then I could also, sometimes I immediately think, oh, that would be a great case for X. Like, for example, in like I was talking to somebody recently from, I think, Tennessee, and right on the call, I thought this would be a great case for lawyer, this lawyer who's actually in Tennessee who does those kind of cases. Like, I think it was like traumatic brain injury, a neck injury, and like a truck with a company car with like an umbrella. And he specializes in that. So like, boom, that's a perfect case for, So yeah, just that'll be helpful. But I'm happy to do a consult. And then RDOT says, what happens when you go to trial and win, but the judgment exceeds the policy limit? Who pays the difference? Right. So it depends a lot on the way everything is built up, right? If you have a bad faith state and you've set it up for bad faith, then you can get more, whatever. If the policy could be open and whatever the verdict is, that they'll pay. If not, then they could just pay the policy and say, look, you have a judgment, but you have to try to enforce it against, the policyholder because there's no more money. So yeah, it just depends on how everything is developed. And Amiri says, how likely is it to get an offer after the demand letter is sent? But again, that depends on like, the way you send it, right? If you send it the old way, like here are the medical records, let's talk. I mean, they'll give you an offer. I mean, you have to send it the old school letter, then you have to get on the phone. You'll probably be on the phone with them for like, you don't want to call right away, right? Because you just sent the letter. So you want them to receive the letter. You want them to give them a chance to like review your letter and all the medical records. Remember, these adjusters, they have a lot of cases. Some of them might have like, I don't know, a few hundred cases. So, don't bother them. It's usually the rule, the unspoken, unwritten rule is like send them a demand letter and then give them like 30 days, and then call them. And then, if you keep calling them, not you, your lawyer should be calling them, and then I'm sure they'll give you an offer, but it might be like really low. It might be a bad offer. That's why I like to flip the script on them and say, look, like I did in my State Farm case, I just said, look, pay me the 100. If not, that's fine. But then look, it's going to be 1.2 million. And I had all the proof why it's worth at least that. This was like conservative 1.2 million. This case could have been bigger, but and I said, and then we're going to hold you in bad faith, even though New York doesn't really have a very strong, bad faith law, but you gotta start somewhere. What are you gonna do? You gotta fight the good fight. That's what I always say. Okay, and then Risa says, I only had 4 weeks of physical therapy, 7,200 in car damages, and about 2,000 in billed medical bills. It's workers' comp and personal injury in Kansas. Estimate rear end accident. So so I need to know like what your injuries are, because see, with workers' comp, that's different. They're just paying you for your lost wages, and they're paying your doctors to give you medical care. So that's money that's going to other people, like doctors, nurses, hospital staff. It's not going to you. What you get, now some lawyers do it this way, right? Like the way you've written it is basically, hey, here are my medical bills. So you tell me my medical bills are, I think what you said, 2,000. They'll say, okay, medical bills are 2,000, 3x that. 6,000, that's what you get. I don't like that. See, I think that isn't really the right way to present a case, because you have an injury and it's an injury to a human being. So what you have to do is you have to find out, like, what did this person love to do? Who did this person love? Do a deeper dive into the biography, tell their human story. And then you could say, look, but maybe he can't pick up his daughter anymore, and that's everything to him. So that's not worth 6,000. That's worth 6 million, right? So that I just think, and then a lot of the best lawyers, what they do is they waive the medical bill because they don't want the medical bills, the jury to even hear it. They just say, look, I don't want any medical bills. I'm waiving it, because it becomes an anchor, right? If the jury is always thinking, hey, there's 6,000 in medical bills, they're going to think, okay, let's give them 3 times that. Let's give them 5 times that. Hey, let's give them 10 times that. But 10 times that is still like, what, 20,000, right? If it's only 2,000. So you don't want to, you don't want to, so you just waive the medical bills and just present the case and just talk about what you can't do and how there's an impact on your life and, like the overall impact. You call witnesses like friends, coworkers, anyone from your life who could tell your story. And each person talks about like 5 or 10 minutes. Like each person tells a story. So one person might talk about your coworker, might talk about how you were at work. Family member might talk about how you are with your kids. Someone else might talk about, hey, we used to play sports. We can't do that. Whoever you have in your life. And you have all these witnesses now. And plus you have a compelling story. And you have, of course, the medical records, the doctors, the bills. I usually like to waive them unless they're really, really high and we're suing for future medical expenses. But that's when the medical expenses could be like, millions. That's different, right? Because then you're suing for that. But if it's just a regular like case of bills, it's probably better just to waive it. And then Askia says, how can I contact you, please? I need more info. Oh, yeah, sure. So please just text me here. I'll drop it in the chat too. It's just 347-566-9595. You could text me. I'm happy to chat. And Joe says, thank you for your answers. Your energy is great. Oh, thank you so much. And then Maboob says, hi, my car accident case is in settlement. I did a left knee arthroscopic surgery. There was a herniated disc at L3, L4, 4 epidurals in the lower back. So what should a fair amount I should accept? Yeah, so I'm happy also to chat with you. I mean, it would depend on like what's the policy, right? Because if it's a $25,000 policy, I mean, you can't get more than that. But if it's bigger, if it's like $1 million policy, if you did an arthroscopic shoulder surgery, plus you did 4 epidurals, I mean, hey, if it's $1 million policy, you could probably get like 300,000-400,000. Also, it depends on like the venue, like how, what's the posture of the case, like what stage is it in, right? If you're already like pretty much done with everything and you're in a position of strength, everything's done well, you have a good trial lawyer, then, you put it on the trial calendar and then you could send one of those letters, hey, pay me $500. If you don't, fine, but I'm going to go to court and ask for 2 million, right? And you have the real goods to prove it. But if there's an issue with the case, then maybe, right, it could be worth less. So I'd have to like really speak with you, but definitely it has value. And then Lost in Awareness says, my case was on the roster for October and the defense put in a scheduling request and now it won't be on the roster again until February. Is that normal? I feel like that's not much significant time between dates. So I don't know if that was for trial. When you say on the roster, maybe that was for trial, but they put a scheduling request and they kicked it. But that's kind of significant. I mean, from October all the way to February. So you lose November, December, January. I mean, 3 months. I mean, I don't know if it's normal or not, because I don't know what city, you're in. Every city is different. Every city has their own like rules, but also every judge is different, right? So one judge might say, these are my rules, no adjournments. Other judge might say, like in Brooklyn, where we practice, there used to be a rule that, once you are past standards and goals, you either settle, select, get the case dismissed, 325D, which means go to the civil court, which buys you more time, or or just go pick a jury and start the trial. There was no adjournments anymore because you're past the court's own deadlines, which we're known as standards and goals. And I think they still follow that to some extent. But in other places, like in the Bronx, you could be way behind standards and goals. Like 2 years later, they don't care, but they're just so busy. But hopefully, I think they're putting in like a system with judges to fix that, so everything's like unified. So it's the same in like Queens and Bronx and Brooklyn. And so hopefully that gets done. That'll be much better. And Amiri says demand was 5 million. Well, I'd have to know a little more. Yeah, feel free to text me the 347-566-9595 because the question was how likely is it to get an offer? I mean, how could I say that? Unless I was like one of those magic balls, like I know everything. How could I say that? Because you're just basically saying how likely is it to get an offer? The demand was for 5 million, but I'd have to know what all the injuries are and what the liability is and all the details. What's the venue? Is that a New York case? It might be a New York case. I can't remember, but yeah, feel free to text me. I'm happy to chat. I'll be around like tomorrow and Thursday and Friday. I'll probably do more consultations Thursday and Friday of this week if you guys are available. And then Everett says, hi, Arkady. I was on a bus with a coach bus company. I tore both of my meniscus and had surgery on both knees. This case is now 3 years. Now the coach had filed for bankruptcy. Yeah, they filed for bankruptcy. So when they filed for bankruptcy, what you could do is you could file a motion to lift the stay. So basically, when somebody files for bankruptcy, there's an automatic stay, which is like a moratorium, meaning nothing could be done. You can't have any activity on the case, right? Because they're filing for bankruptcy. And so that's one of the protections you get under federal law is a stay on all lawsuits. So, but you could lift the stay and you just have to agree to proceed against the insurance, because I'm sure that bus, Coach bus, that's a big company, Coach, right? I'm sure they had insurance for the bus. So you're not really trying to sue Coach. You're not trying to take their buses or take their money. You're suing the insurance. So whatever insurance they had like $1 million with like a 3 million excess. I'm sure they had good insurance. Just go after them. And then your lawyer should know how to do that. That's pretty easy. It's like a template motion. And then you just go after the insurance. And then you'll be fine. It might delay the case like a month or two. And then Joe says, on average, how many phone calls do you have with lawyers and adjusters during a case? Maybe it's a weird question. I'm just curious. I mean, I would say, look, as a handling attorney with lawyers, you could have maybe, it depends on, on the case. You definitely are going to have a few phone calls, maybe like 10, 15, it just depends on the case. Sometimes if you're in some kind of issue where you need to discuss something, you could do like Zoom calls, or you could meet in person. With the adjuster, also could be less. With the adjuster, it could just be like, 3 or 4 calls. I don't like to do the whole back and forth, a dance. Because if I know I have a good case, I'll just set the value and I'll tell them, hey, pay me my number. If not, then I'll go to court. And that way you kind of don't waste your time with all this, calling them up, begging for money. They're telling you no. and you got to come down, and then I have to bid against myself. Like, why would I want to do that? I think the whole thing is silly. I think the whole negotiation thing, the way it's set up right now, it's really in favor of the insurance companies. I think they set this up and they got it like entrenched into the courts. Because even when you go to court, the judge will say, "What's your demand?" Well, my demand, I don't want to have any demands, right? The demand is like I'm begging for something. I don't want to have beg for anything. I'm going to tell you, look, the value of this case is $1 million. Pay it. You have 30 days. But once it hits like December, let's say December 12th at 5 p.m., if you have this opportunity, you have an opportunity to pay my $1 million. If you don't want to and it expires, great. We're going to go to a jury trial. But then the minimum, I'm going to tell the jury that when they match up the law and the evidence, a verdict of $5 million will be justified. Okay, there we go. I actually did a video about this too. I think it came out, I don't know, because I haven't actually watched it. I just kind of did it, but the guy who was shooting it said it came out pretty good. It was me talking to an adjuster, and it was the two different ways you talk to an adjuster. The old school way where you just kind of like, and then the new way with the settlement opportunity that I like. So it was funny. So watch out for that one too. It should be coming out soon. And Bothrop says, "Hi, Mr. Frekhtman. Had my deposition back in June of 24. What's next, and how long does it take to see a judge or to settle?" Yeah, so I mean, that's going to depend on where you are. Every jurisdiction is going to be a little different, but generally, after a deposition is done, now your lawyer may have to take depositions of the defendants and question them, to prove the case. And then once that's all done, you put it on the trial calendar. And now you're on the trial calendar, and then you're going to get a trial date. Unless you're in a different venue, then it might just be you get a trial date. Like, some places, like you file a lawsuit, they give you a trial date. Like I file a lawsuit today, they'll say, "You're doing a trial in 2028. So every place is a little different. And Lost in Awareness says, "Do you think it helps to settle a case by telling the defense that you're going to ask for more than the policy at trial?" Yeah. Well, that's exactly like the idea, behind this whole settlement opportunity, because I'm giving you an opportunity to settle within the policy limits. But if you squander the opportunity, right, and I'm giving you everything, like, look, come to my office, meet my client, you want to talk to the witnesses, whatever you want. You want here's all my medical records. Is there a medical record you don't have? Let me get it for you. Give them everything. Just be like, look, I'm being fair. I'm not trying to hide the ball. Like, here's everything. This is your chance to settle the case. You have 30 days. You need more time, as long as you're trying to settle in good faith. If you need another 30 days, whatever you need. But then if you're not going to take this deal, if you're not going to settle the case, then why should I ask for, I don't care what your policy is, 100 or 250 or whatever. I'm just going to ask the jury what's fair when they match up the law and the evidence. What's civil justice in this case? What is it really? And really, look what I have. I have future medicals. I have lost wages. I have pain and suffering. I have lost enjoyment of life. Really, it's huge. It's like $5 million, right? So I think it's a good way of doing it, but not a lot of lawyers are doing it. There's one lawyer that I learned it from that wrote the book on it, and he does it, but he gets like crazy numbers, like 19 million, 25 million. So it's a good system. It's a better system, but you have to be willing to go to trial. You have to be willing. You can't just be like bluffing. Then like, this guy's just bluffing. He's a blowhard. You have to be willing to go to trial on it. But yeah, definitely it helps, I think. And Paul says, "Arkady, do you know if cases are still backed up because of COVID? The process seems to be slow in New Jersey, maybe in other states also. Just a thought." Yeah, I mean, it could have some effect. I think that it's getting better. I think just like after COVID, especially in New York, it just seemed like, I don't know, everything kind of changed a little bit. Everything changed a little bit to the point where they just haven't been settling the way they were before, also the courts just slowed down a little bit in the sense that, I don't know, before it was like more activity, you could call, that would be helpful. It just seems like now, I don't know if this is true for everywhere, but it seems like some places it's a little bit like lazier or something, or they just like don't want to work, or they just like want to yell at lawyers, like, "Oh, why did you do this? Why did you do that?" Just hang up on you. but I don't know. But like, I think courts are back, obviously. But yeah, there could be. I mean, the short answer is yes. There probably is some sort of a little bit of a delay, but cases are moving. It's just like the new kind of like everything changed, the new normal, the new world. But things are moving. And on the MC says, can you appeal a case that was settled in 2012? A very promising case that was very undervalued. Trimalleolar ankle break. No, if it was settled, then you can't, right? Because it's settled. It's done. And then Amiri says, I'm in Georgia, liberal venue outside of Atlanta. Oh, he says, oh, okay. He's got the TL4J. Oh, yeah, that's the firm I work with. Okay, yeah. Oh, then you're in good hands. Yeah. Oh, so that's the 5 million that you're talking about. Yeah. So no, with them, they may give you the 5 million or close. They'll probably talk, real money with you because those guys are really good. They're like real trial guys. And Joe says, I'll definitely watch it about the video. And Baby Boy says, Jody says, hey, buddy, I love you. Oh, wow. Thank you. And on the MC says, this case is intertwined in my negligence of my recent undiagnosed pulmonary embolism. Oh, I see. Yeah, that's serious. That's really serious. I know a little bit about that. Actually, one of the lawyers in our firm had that. Yeah, that's real. And I've done some cases with that. That's really serious, the pulmonary embolism. Yeah, you have to be, oh, wow, I see what you're saying. But if it just depends. If you settled the case and you signed the release, you probably can't reopen it, especially 2012. That's a long time ago. Paul says, thanks. Oh, you're very welcome. And Jody says, hey, if I have to go on permanent disability, does that help my case from my car crash? Yeah, I mean, it definitely helps because if you have to go on permanent disability, it means you have this finding, right? And some of the findings could actually be used. You could say that in court, hey, I have this finding that I've been found disabled by, this, whatever, the state, or sometimes the workers' comp also comes in so that could be, it's known as res judicata because you can take it from one court and use it in another court. So that could be helpful. And Abdul says, how long does it take to get your settlement check from New York City? Okay, so if it's New York City, it's usually 90 days. It's a little longer. They have 90 days. But it actually goes by kind of fast, though, for some reason. I always just diary it in the calendar before you know it. Hey, here comes the check. But yeah, it's 90 days with New York City. Usually with private defendants, it's 30 days, so it's a little quicker. All right, so let's see. Do we have any other questions? Or let me see if I have anything in the channel that people were asking. I did do a video recently, I think it was also last week, where I talked about like some of the questions that people write in the channel. So it's like more of a last week tonight episode where I was reading it and I answered it. And there are actually some good questions. I think it turned out to be a long episode because there were a lot of good questions. Yeah. And then the hire says, is it typical for cases to go past the 2-year mark? Yeah, I mean, they definitely can, especially if they're in litigation. Litigation usually could take more than 2 years just because you have to go through the whole process, and it is complicated, so it takes time. And then we have a question here. Hi, 2 doctors recommend PCDF after a rear end by a van in New York City. So a cervical. Is that a ACDF, you mean? Like an anterior cervical or posterior cervical discectomy infusion? Oh, yeah, posterior cervical. So that might be with the rods. That's actually more involved than the anterior. I think that's more serious. Oh, yeah, that could be a multi-million-dollar case as long as the van has enough insurance. But feel free to text me. I'm happy to chat with you about that. And then Zafraz says, hey, Mr. Arkady, my lawyer filed a motion in court. Defendant lawyer wanted a second deposition, but I didn't do any new treatments. How long does it take to get a decision? Yeah, usually like just, a few weeks to maybe a few months. It shouldn't be too long, something like that. I don't know what's the reason for the second deposition. Either they found some new evidence or there's got to be a reason, because otherwise they wouldn't be entitled to a second deposition. If you haven't done any additional like surgery, then there's no reason for a second deposition. They already had a deposition. You can't just keep deposing the same person over and over again. So yeah, you have to look at the actual motion or ask your lawyer, what's the basis for it? What's the reason they want this? But yeah, the decision shouldn't be long. I mean, usually like 60 days, 90 days for the most part. I'm trying to see if there's any questions that I haven't answered in the that are interesting in the channel as well. I think I did, because the last week tonight that I did last week, I did it last week and it's called Last Week Tonight. It's funny. But anyway, but it was like 36 minutes. So it was pretty long. I think we did a lot of the questions at that one. Okay. And then on the MC says, last month I was in the hospital with many signs of stroke like symptoms. The ER let me go with undiagnosed pulmonary embolism and just DVT. There was no CAT scan, and let me go home with a blood thinner to be filled. Oh, I'm sorry to hear that. Yeah, that's terrible. Yeah, sometimes these doctors, they make mistakes. That happens a lot. You know, you have to be very careful. Yeah, it's really, really true. And Kevin says, hey, hi, Mr. Arkady. Have you ever dealt with a case where the EUO was involved for underinsured motorist? How would this play out? Oh yeah, so EUO is just when they do an examination under oath. It's like a deposition. They just ask you some questions. So uninsured motorist, yeah, it could be. That's not really like one thing doesn't really have much to do with the other. It's like the reason they might want the EUO is just to make sure that, you know, to find out how everything happened, find out about your medical treatment, find out a little bit about your injuries. My attorney recently just filed a lawsuit because they requested an EUO after the other party paid out their policy limit. So the other party paid the policy limit. Oh, that's why you're going UM, right? Because you got all the money from the defendant. Now you're going UM. So yeah, they could do an EUO for that, of course, just to make sure everything is like proper. Basically, it gives them an opportunity for discovery, find out what happened, right? So that's pretty standard. Yeah. Yeah, so let me see. Trying to see if there's any other questions in here. Anyone has any questions here? If not, I guess we could wrap it up. We're almost at 47 minutes. Yeah, we're almost at the hour mark. So I guess that's good. We could do another one, maybe like could see maybe do another one on Thursday. Oh, Kevin says, I did a Google search and got scared because it all showed fraud, which there is no way that's possible. I'm just confused. Oh, yeah. Well, sometimes they do an EUO if they suspect fraud, right? So, for example, if they have like, I don't know, 5 people in a car and the car does one of those like swoops or whatever and the short stops and then somebody hits them, like usually like a commercial vehicle. And they're like, wait, how do you people even know each other? Like, you know, the passenger A doesn't even know what passenger B is. Like, I don't know, I just got into the car, then it's a little fishy, right? But yeah, your case isn't fraud. So, I mean, sometimes that happens, but I think in your case, it's more about the actual, you know, everything. They want to basically evaluate the case, because if the policy was already paid out, that means the injury was pretty significant, right? They don't just tender the policy for nothing, right? So now you're going UM. Oftentimes when you go UM, your policy is bigger. For example, they have I don't know, 100, but I have a 500. So now my carrier has to pay like 400,000. So that's a lot of money. So they want to make sure that they really have to pay it, that they don't have any defenses. And they want to go through like, what's the liability? What happened? Does it qualify? Was there really contact? You know, can they say, sometimes people say, hey, I want to start like an uninsured motorist case, but there's no actual contact, you know, and if there's no contact, then there's no UM claim, right? So there's, you know, so there could be liability issues, there could be damages issues. They want to see if the injuries are really from the crash. They pretty much want to dot their I's and cross their T's because they're about to pay, like, you know, a lot of money, right? So that's basically That's basically just like a due diligence type thing. I wouldn't really worry about it. It's pretty standard. Yeah. Okay. All right, everyone. So thank you so much for being here. Please like and subscribe to our channel. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families. And let us know how we can help you. If you want us to do a video about a specific topic, just let me know. And yeah, and all the best. Have a great night. And we will talk to you very soon. Okay. Bye-bye.